and gentlemen, I always feel fortunate that I can still use that greeting in these gender-fluid times that are increasingly restrictive and perma-offended. I speak for marriage and against any misnomers such as same-sex marriage, transgender marriage, child marriage, polygamous, polyandrous, polyamorous marriage, and so forth. Marriage Alliance is apolitical. It has supporters who are young and old, gay and straight, atheist and believer, migrant, Indigenous, Australians all. We are a hub which is growing by day. I'll talk briefly about 4 points, and altogether it'll be about 20 minutes, and then we'll go to questions with the panel. I'll talk about marriage in history, marriage in Australia, the overseas experience where same-sex marriage has been legalised, and why the Australian people should decide this issue and not our Parliament. Marriage came about as a sensible arrangement for the survival of the human race. It has been around in every culture in the world since time immemorial. It is therefore cross-cultural, timeless, and predates registration by the machinery estate. The Parliament does not and never has bestowed the right to marriage. It merely recognises it and protects it in law. The Hammurabic Code of 1754 BC, one of the oldest existing records of legal codes, deals with marriage, and you can view it in the Louvre in Paris. Rights and obligations arising from marriage in relation to property ownership, debt, succession, expectations of spouses and children have varied across cultures. But always, the institution of marriage has been understood as being between the opposite sex. This fact has been respected in cultures internationally, even when there was tolerance of homosexuality in ancient Greece or Rome. And until recently, this fact was respected in modern Western civilised culture. Marriage makes sense biologically, theologically, and philosophically. Biologically, the sex organs of the human body are designed for each other, and there is no child created without a mother and father. Theologically, in all the major religions of the world, marriage between a man and a woman is not only a traditional societal ritual, but it is a sacrament. So Christianity, Judaism, Hinduism, Islam, and so forth. Philosophically, it reflects the natural law-based human right of everyone to marry and procreate. It is now part of international law, having been formally recognised in the Universal Declaration of Human Rights at Article 16. In 1901 at Federation, the Commonwealth gained powers to make laws with respect to marriage, so it's Section 51 Placida 21 of the Constitution, and it used this power when it passed the Matrimonial Causes Act of 1959 and the Commonwealth Marriage Act of 1961. Marriage is currently governed in Australia by this Act, and in it, marriage is defined as the union of a man and a woman, to the exclusion of all others, voluntarily entered into for life. This was the common law definition, by the way, and it was spelt out formally in the Marriage Act via amendment in 2004 by an overwhelming bipartisan majority in Parliament. It didn't actually need to be spelt out before because people the world over knew what marriage was. I'll return to that point. Under our Marriage Act also, Section 88EA, certain unions are not marriages, such as between a man and a man, a woman and a woman. Bigamy, polygamy, polyandry, incest and marrying a child are also not permitted. In 2013, same-sex marriage was legalised in the ACT, then struck down by the High Court for being constitutionally invalid. In summary, the court found that the Commonwealth covered the field of marriage as per the Constitution, so the states and territories could not. I'll return to that case in a moment. Currently, some states have some form of couple registration. Under federal law, these unions are treated as de facto unions. In 2009, the Australian government introduced reforms amending 85 Commonwealth laws to eliminate discrimination against same-sex couples in a wide range of areas. These laws removed any differences for same-sex couples in taxation, inheritance, superannuation, health insurance, social security, aged care and child support, immigration, citizenship, veterans affairs, so people can rest assured that there is no discrimination in Australian law against same-sex couples. They are treated as equal. There's no disadvantage to being a couple of any kind in Australia. Same-sex legislation has been introduced into the House of Representatives on 18 separate occasions. It has been defeated in each and every case. In August 2015, it was decided by a majority vote in the government coalition party room that this was a matter relating to our social infrastructure and was of such sensitive and emotive nature that it should be decided by the people. Allowing the people to have a direct say on the issue was then part of the coalition platform at the recent federal election. What we are talking about is whether the concept, the word marriage, should be redefined. Marriage is a particular thing. It is unique. Like water is H2O. Water is not milk, for example. They are different. To acknowledge difference doesn't mean we are being mean to milk. Blurring the two issues of discrimination and marriage redefinition is what the same-sex marriage activists are trying to do. It is simply not correct. Some of the advocates of same-sex marriage frame it as a human right. They argue that equality means there should be no difference in treatment, even where something is clearly different. But the history of discrimination law has found consistently that to treat people the same way where there are demonstrable differences, that is discrimination. To treat unlike as like is actually wrong. Sameness is not equality. For example, in sport, there are different requirements of women than men, which recognises that women have different physiques. Marriage is a particular thing, one man and one woman, based on their complementarity, and it is the fact of opposite sex which makes it marriage. The European Court of Human Rights confirmed this when it found unanimously in June of this year, in the case of Chapin and Charpentier and France, that for a nation to not legislate in favour of same-sex marriage was not a breach of human rights. So what's been the overseas experience? At the time of writing this paper, about 20 countries have redefined the definition of marriage, and 176 countries have not. The general method has been to introduce it swiftly, shunt it through the Parliament, and not allow the matter to go to an informed population. If Australia holds a plebiscite or a people's vote, it will be one of only a few nations to do so. Croatia held a referendum in 2013. 65% voted to lock the man-woman definition into the constitution, thereby locking out same-sex marriage. In 2015, Slovenia held a referendum and likewise rejected a same-sex marriage bill. They also locked the man-woman combination into their constitution. In Ireland in 2015, there was a referendum with a different result. The result in favour of same-sex marriage was approximately 62%, but only 60% of the population voted at all. So yes to same-sex marriage, but only from 34% of the actual voting population. Canada legalised gay marriage 10 years ago, no public vote. Already people are being litigated against in business for not wishing to participate in the gay marriage activity. Parents have had their rights curtailed with respect to their children's education. And more recently, law graduates attending a Christian university are told that they will not be allowed to practice as lawyers. If you like, you can Google the Trinity Western University cases. So because they attended a Christian university, it's not about the quality of the law degree. It's because they went to a Christian university which had a covenant saying you are not to have sexual relations on campus unless you're married, and marriage is between a man and a woman. From Ireland, we learned of the famous Ashes Bakery case, where a bakery was successfully sued for not providing a cake for a gay activist event. It was basically an order for a cake which had an activist slogan on the top, support gay marriage, and had Bert and Ernie. And the bakery, it would have gone out from the bakery in the baker's box with their company logo on it. Last week, the bakery lost their appeal. The facts in that case are not momentous, but the symbolic power and the impact of the judgment is enormous. This means that gay people can force others to participate in their activism, even against other people's consciences. This does not bode well for harmony in any democracy. In the USA, in the Sweet Cakes by Melissa case, a family-run cake shop was fined $135,000 and closed down. An Asian couple who were photographers and who simply did not do gay weddings were sued and were forced to close their business. An elderly lady florist, Baronelle Stutzman, 8 children, 23 grandchildren, was also sued. She, as in all these cases, gladly served gay people and had a history of doing so. She just didn't wish to participate in the gay wedding activity in any way for her own religious or private conscience reasons. The first person to be imprisoned over this issue was last year in America. A judge ordered Kentucky clerk Kim Davis to jail for 6 days for defying his orders to issue same-sex marriage licences against her conscience. And I've just recently read a paper analysing the fallout in Argentina. It has affected laws detrimentally, ranging from women's rights, children's identity rights, to artificial reproduction, surrogacy, adoption, employment, tax and inheritance laws, and forced to comply with a gender-neutral paradigm. None of this has been examined publicly, adequately, or at all in Australia. But we cannot ignore these overseas cases because they have happened, and many more instances never see litigation. People can't afford it. They have shown us, these cases have shown us that those advocating for their alleged right to change the definition of marriage do so at the expense of others' rights to freedom of speech, freedom of religion, freedom of conscience, and the right to privacy on the issue. So what's happening in Australia? Catholic Archbishop Julian Porteous, who has a duty to inform his flock, circulated a respectful booklet. It was a pastoral letter in the form of a booklet to the parents of Catholic school students, and it contains standard Catholic teaching on the subject of marriage. He was then the subject of a complaint to a commission for having breached the Tasmanian Anti-Discrimination Act. What this case highlights is that if same-sex marriage is legalised, the rights of religious schools to have their own employment policies and create their own curriculum content based on their own teaching about marriage could well be compromised. We don't force doctors to do euthanasia or abortions. We don't force butchers to sell halal meat. We don't require Jewish restaurants or caterers to sell pork. And yet all the indicators are that on this particular issue, it will be forced on us, participate or be sued. This is not the straitjacketed Australia that anyone wants. Why I defend marriage is that marriage has served Australia and its children well, and it will continue to do so. It does not need to be redefined. We do not need the societal fallout witnessed overseas. If you want to build a building in Australia, you have to provide an environmental impact statement. It has to show the benefit of the structure, where the problems are, and how these will be addressed. Where is the social impact statement for this monumental change proposed for our social infrastructure? The same-sex marriage lobby needs to explain how that change will benefit society, where the anticipated problems are, and how those will be addressed. They should be reassuring us how our rights, if we disagree, will be protected. The onus is on the change agent. They are pretending change will be minimal, just the changing of a word. The overseas experience clearly shows that this is false. It is much more than that, and it is causing misery. It has given people a weapon against others to force them to endorse this new world view. There are no safeguards being offered, or very limited ones, to clerics. Why would we ever agree to changing the definition of marriage? Australia needs to learn from the ruthlessness that's been shown overseas. It must carve its own path, and we need a people's vote, and it needs to be an informed vote. Which brings me to the plebiscite that's on offer. The Australian people should decide and not Parliament. Now, there's no doubt about that. Knowing what I know about vote trading that takes place over legislative subject matter, be it shotguns or building commission watchdogs or whatever, the marriage issue is too important to be traded away by people who may not feel strongly about it one way or another. Further, now I should mention now that I'm speaking in my own capacity now, not as a representative of Marriage Alliance, because what's on the table is actually a plebiscite at the moment. So our outfit is dealing with what's on the table at the moment. But I do want to take you down the path of considering the option of a referendum. So the idea of representational democracy is to have a voice for the people, which is yielded up in each federal electorate. That person then goes to Parliament and champions the cause of those people. Nowadays, and I can only say what I've observed in New South Wales, in both major parties, the factional influences have infected pre-selections to the point where the winning candidates do not represent the people anymore. They represent factional interests, which can include union bosses or lobbyists with private commercial interests. There is also not one vote per party member. Not one vote per party member in a democracy. And so many high-quality candidates do not even bother putting themselves forward for consideration. So the idea that the parliamentarians will produce a result which reflects the will of the majority of people on the marriage issue is actually doubtful. I should mention the same-sex marriage vote has been, I mentioned it earlier, it has been before the Parliament 18 times already, and that takes up a lot of time and money and energy of the Parliament. It's always been defeated to date, but the trading of votes dynamic and even bullying of certain MPs over the issue means that it is now overdue. It should go to the people. I'm going to outline the proposition that the best path for Australia might be to, in fact, pursue a referendum rather than a plebiscite. This proposal would see the locking into our constitution of the definition of marriage, the union of a man and a woman, to the exclusion of all others, voluntarily entered into for life. I'll give a few reasons and we can discuss them more fully afterwards. So, as we all know, a plebiscite is not binding. That's simply the nature of it. A referendum would be binding. Secondly, it would stop any more pressure being brought on the nation on this issue. The same-sex marriage activists, even if they lose the plebiscite, might not accept the result or accept it for very long. In fact, Tony Blair in Britain is now agitating for another vote on the issue of Remain or Brexit. And the people have spoken. Theresa May will stare him down, I'm confident. But what if there was a weaker politician? Thirdly, it would prevent activist judges, so this is a referendum over a plebiscite, it would prevent activist judges breaching the separation of powers by becoming quasi-legislators, and it would also stop them usurping the role of the people in changing the Constitution. Let me explain that. The separation of powers, as we all know, requires that legislation be made by the government, the lawmakers. It faces debate in the Parliament and it has to pass both houses and so forth, and it's administered by the executive. The role of judges is to interpret the law. They cannot simply make it up on their own. Legal formalism, which describes the discipline of adjudication, requires that judges apply legal principle to the facts and do this without social or political influence. Formalism includes the originalist approach, which is that judges will interpret according to the original meaning given in the Constitution. So we're not Canada, where they have a living tree doctrine, and we also do not embrace the realist perception, which wants activist judges. I'll just explain. So-called realism is the antithesis of formalism, and the realists who started in the 70s or wherever, they actually wanted judicial creativity rather than mechanical black-letter lawyer interpretation, as long as the creativity was not along conservative lines, only progressive. Does that make sense? And there's a good paper that you can read on it by Justice Antonin Scalia, the late Justice Scalia, The Rule of Law as a Law of Rules. Law and policy is decided by politicians who take their proposals in a platform to the people, who then give consent, or the go-ahead, if you like, in an election in a private ballot. And a people's vote, rather than a poly vote, was actually what was put to the people in the recent federal election. And the winning party, the coalition, was the one that put it to the people. Our Constitution grants the marriage power to the Federal Parliament, as I mentioned earlier, Section 51, Placido 21. The Constitution may only be altered by the vote of the people, Section 128. What we saw in the case of ACT and Commonwealth 2013 was the ACT trying to enact a same-sex marriage law. The court held that the whole of the ACT Act was inconsistent with the Commonwealth Marriage Act. And what the High Court could simply have said is that the Constitution granted the marriage power to the Federal Parliament, and ACT, you have no power to do it, sorry. But what they said instead, on page 13 of a joint unanimous judgment, was, when used in Section 51, Placido 21, marriage of the Constitution of 1901, square brackets, marriage is a term which includes a marriage between persons of the same sex. Well, let's just unpack that a bit, shall we? In 1901, homosexuality was a crime, so it is doubtful that the word marriage in the Constitution would have included criminal practices. And fortunately, society has come a long way since then in the subject area of gay rights, and that's a very fortunate thing and a good thing. We also have the benefit of Quick-and-Garron's 1901 annotated constitution, written at the time, published at the time, and it gives the contemporaneous details of what marriage means. Marriage has only one true meaning, and it's given in that annotated constitution. And so, despite what we are being told by some Western politicians and marketers for same-sex marriage activism, this doesn't change the meaning of marriage. It is historically understood in humankind, it is consistent with natural law, and for a couple of thousand years it has had a sacramental meaning in all the major world religions. This all remains the case no matter what the marketing has been. Does that make sense? So, and with the known fickleness of the West and the trends that come and go, this current activism may turn out to be a mere blip in the timeline of humanity, that the meaning is claimed to include all sorts of other combinations. The bottom line is that any judicial interpretation which has the effect of altering a key term in the Constitution cheats the Australian people of the chance to amend a key term by the constitutional mechanism outlined in Section 128 via referendum. This is actually appalling, and I say this with the greatest of respect to the judges concerned, and I mean that, and I know that there are judges in the room, and I have immense respect for the judiciary. We are at the point where our High Court has decided that marriage in the Constitution includes same-sex marriage, contrary to the relevant annotations of the time, contrary to all contemporaneous evidence available in Australia and humankind at the time. The founders of our Constitution were aware of different marriage permutations in the world then, such as polygamy, for example. There's long-standing tradition in some cultures and religions. But the definition in our Constitution did not allow for that, or any other combinations. Different combinations ought not be retrospectively put into it via dubious and unconstitutional channels. It should go to the people via referendum, and any change to the meaning of marriage should be done in accordance with the Constitution. I'll save the rest for the Q&A. Thank you very much, and we welcome questions.